client where then maybe. But how often do we see that? We don't see that very often. To the contrary, most of the people that I'm looking at have been struggling to hold on, and they've been using their credit cards to supplement their income simply to try and hold on. Now with the Obama's intervention with the credit card companies, we're seeing credit lines cut and interest rates going up. Credit card payments are going up. People have lost complete control. Their credit's it's a goner. Why are we talking about credit? Does it make sense?
Yes.
Kind of makes sense. Now here's an area in consumer protection laws. You can't put a disclaimer in a contract disclaiming that you're denying that you're providing any type of credit repair, and then turn around and provide credit repair and think that the disclaimer buys you something. I don't want you on the receiving end of a consumer protection lawsuit. I had one client about 3 years ago get hit with one, and it cost them high six figures. It wasn't a realtor, it was a financial institution, but they're hurtful. The question becomes, is credit repair ancillary to other services you're providing? So that's why I say this really depends upon what it is you're telling the client. If the whole subject matter is credit, then the short sale sort of becomes ancillary to credit repair. Not the other way around. Got to be careful. You've got to be careful. Is what you're saying to the client about credit ancillary to credit repair, or is it credit repair? Practicing law without a license. What can you say about the law? Don't go and do not apply the law to the facts of the client's case. If you can avoid applying the law and as to how it applies to the client, you're doing well. The minute you start applying the law to the specifics of your client's case, then you cross the line. You cross the line. Think of it, use some common sense here. You shouldn't do that ever, but especially if it's a transaction measured in hundreds of thousands of dollars. Because the client's going to be the one that suffers the detriment. And trust me, he's going to want you to suffer the detriment. Foreclosures. A foreclosure is a legal proceeding. It has legal significance. It has legal consequence. Should you be sharing those legal significances and consequences with the borrower? What about on the contracts? On the promissory notes? A promissory note, a deed of trust, they're legal documents. They're legal contracts. Should you be counseling the client to not pay on the contract to get some sort of advantage in a short sale or a loan modification? No. You're telling them to breach a contract. You're telling them to breach a contract. It has legal consequence. You can go there if you're willing to put your money behind you to back it up. Otherwise, don't. Because, ladies and gentlemen, I am, in all sincerity, I have grown men and women coming to my office in tears, crying over the consequences of a short sale, a loan modification. I had one woman go into cardiac arrest. An ambulance had to come wheel her out. She came in on her own 2 feet. She left on a gurney. Because as she was sitting there, she was realizing the consequences of the decisions that she had made and what they meant to her. I give it to people straight. I mean, this stuff is complicated. Because the lenders don't let up. They want their money. Just because the short sale is done doesn't mean that the lender's necessarily done. Okay. That's right. Let's see. Now, given everything I've shared with you today, does that exist? Does that exist at all? No, it doesn't. Don't sell it. The problem with a short sale in comparison to a normal sale is it's a battlefield. You've got combatants that are jockeying for position over one another. The homeowner is trying to get out of a debt. The creditor is trying to collect a debt. Come on, guys. I mean, that's what's going on. It's the nature of the beast. A short sale is a contentious sale. Puffery versus fraud. This is actually from the Realtor Code of Ethics. Be careful. You know, I don't know what it. I haven't looked, but what's going on with Matt Battiata? I am getting so many calls these days. I don't know what he's doing. I haven't looked, but it has something to do with stuff on his website. I don't know, but it suggests to me that maybe we need to visit this. Puffery versus fraud. Puffery is permissible. Fraud is not. Puffery is characterized by the general rather than specific assertions. Puffery consists of generalized, vague, and unspecific assertions upon which a reasonable consumer would not rely. You must avoid exaggeration, misrepresentation, or concealment of pertinent facts relating to the property or transaction. This is under the Code of Ethics that applies to realtors. You know, be careful what you say about all this, because as you can now tell, it's really hard, because a lot of this is random. We don't know how the powers to be are going to exercise discretion, and when they do exercise discretion, how that is necessarily going to trickle down to us. I think of a short sale, ladies and gentlemen, of a pachinko machine. You ever see a pachinko machine? I don't know if they still have those or not. When I was a kid, we had them. I may be dating myself, I don't know. It's sort of like a upright pinball machine, right? You get a little marble, you let it go, and it's got all these little nails inside of it. You could sit there and measure with the utmost effort and precision to release that ball the exact same way each and every time. And does that ball fall in the exact same spot every single time? No, it doesn't. And that's the problem with these short sales, is you can't predict where that ball is going to go, because there's so many prongs involved in it that come together, have to come together just right for that ball to filter through the system and land in the exact same spot time and time and time again. It's tough. It's very tough. So the best you can do with a client is advise him that, hey, we got a pachinko machine here. It's got a lot of spikes. We don't know how it's going to work out. You got to go talk to a tax professional. You got to go talk to a legal professional. E&O insurance. If you're going to get involved in assisting homeowners in mortgage distress, please, pretty please, I'm begging you, make sure you have E&O insurance. Check with your employing broker. Make sure they have E&O insurance. Make sure you're covered. If you're not, go get your own policy. If not, I'm here. Is it expensive?
Yes.
Why do you think it's expensive? It's risky business. If it wasn't risky business, it wouldn't be expensive. But ladies and gentlemen, if you don't have it and you get sued, you have just put you and your family in a position where no matter what you do, you're being separated from your money. whether it be through a bankruptcy, to a lawyer to defend yourself, or involuntarily to the creditor. And the creditor is going to be the client. If you're on the receiving end of a lawsuit, even if you win, you're still doing one of these. Still writing checks. I don't want you to go there. I'm a big fan of insurance. Now, we are starting to receive an increased number of calls from clients, homeowners, who are doing short sales. And they're saying, my agent is trying to get me to sign a promissory note. The bank